Okay, welcome everyone to this week's Business in 2022 weekly webinar. I am your host this week. Next slide, please. As we do every Tuesday, we're going to start off with some COVID data. The data is not great, as you will see. We're seeing a spike of cases, particularly in New York City and the surrounding areas, but again, no new regulations or rules that have been implemented by the State Department of Health. I will note that the New York City Department of Health recently issued a recommendation that individuals in public places, indoor spaces, wear masks, but this is not a rule. We're still at the recommendation phase. We haven't seen a rule put into place yet, but as we've all seen, that can change probably this afternoon, because that's how it's worked over the last 2 years. We'd present a webinar with the current rules, and then a couple hours later, there'd be a change. So we will keep an eye on that for you, and to the extent anything changes, we will make sure to let you know. As you can see, the current daily average as of July 18th in New York State is approximately 7,700 cases. Unfortunately, that's a 72% increase over the past 14 days, which is not great. The hospitalization numbers are going up, as are the ICU and death numbers. Now, those are lagging statistics. So typically we see the increase in cases followed thereafter by the increase in hospitalizations, ICU admissions, and fatalities. Hopefully we do not see that kind of spike, but that's the pattern we've seen in the past 2 years. Next slide, please. Okay, so I think that this color-coded graph shows what I was talking about very clearly. You see that New York City, Long Island, and the surrounding areas are experiencing the greatest increase in cases. We're still seeing New York City up on 32% over the last 14 days, which is not great. Tioga County, for some reason, is experiencing a very significant increase. The numbers are so small, though, that the statistical percentage increase is a little deceiving. But we see numbers are, in general, going up, which is not great. Again, no policy changes to date, but we will keep an eye on that for you. All right, we have a packed program for you today. Next slide, please. And we are going to start it off with a law that was recently passed and signed by the governor in response to a Supreme Court decision. So here to talk to us about that new gun legislation is Nick Jacobson. You know Nick, if you have been following this webinar for the past couple of years. Nick has presented on a number of occasions, always does a very nice job. So Nick, the floor is yours.
Thank you very much, Adam. Next slide, please. So since 1911, New York has prohibited the unlicensed possession of firearms. To possess a firearm inside of your home or business, you're required to demonstrate, among other things, that you have good moral character, that you have no history of crime or mental illness, and that no good cause exists for denying you a license. For example, there's no order of protection against you or something of that sort. But there's increased restrictions if you're looking to possess a firearm outside of your home or business. Next slide, please. Until the recent Supreme Court decision that Adam referenced, to possess a firearm outside the home to conceal and carry it for self-defense purposes, individuals were required to show proper cause for them to have a permit to do so. To show proper cause required more than a general need for self-protection. It's not enough, or it was not enough, to say, for instance, that you lived in a high crime neighborhood or something of that sort. What was required was that you demonstrate that there were specific threats or attacks against you that were different from what members of the general public experienced, that justified you concealing and carrying a weapon for self-defense. Without proper cause, you could still get a license to publicly carry firearms for specified purposes such as hunting, target shooting, or employment, but without proper cause, you were unable to get a license to just generally conceal and carry a firearm for self-defense. Next slide, please. The proper cause standard was recently challenged in a Supreme Court case, New York State Rifle and Pistol Association v. Bruin, in which two Rensselaer County residents challenged that standard. They both applied for conceal and carry permits based on a general interest in self-defense. One of the applicants actually cited an increase in burglaries and break-ins in his neighborhood in support of his application, but both individuals were ultimately denied a concealed carry permit. On challenge by those two individuals, the Supreme Court held that the proper cause standard was an unconstitutional restriction on individual Second Amendment rights. While they held that the proper cause standard wasn't appropriate, the Supreme Court did acknowledge that guns could be prohibited in certain sensitive areas, almost seeming to want to head off any legislative activity by New York. The court went on to say that while it wasn't going to define what constitutes a sensitive area, it did caution that, for instance, the island of Manhattan could not be categorically denied as, or defined as a sensitive area. Next slide, please. In response to that Supreme Court decision, the New York legislature acted quickly, and on July 1st, Governor Hochul signed new legislation in response to that decision. The legislation prohibits individuals from carrying firearms in sensitive locations. Sensitive locations include government buildings, healthcare facilities, religious institutions, libraries, public parks, schools, and colleges. And the law also prohibits the possession of a firearm on public transportation or anywhere licensed to serve alcohol or cannabis. Next slide, please. In addition to designating sensitive areas where the possession of a firearm is prohibited, the legislature also prohibited the possession of firearm in restricted areas. And they defined restricted areas as private property where the owner has not posted clear and conspicuous signage stating that the possession of firearms is permitted or otherwise given express consent allowing the possession of firearms. Certain individuals are exempt from this prohibition, including current and retired law enforcement officers, peace officers, licensed security guards, and active duty service members. But in general, individuals would be prohibited from possessing firearms on private property unless there was clear and conspicuous signage allowing them to do so, or some other form of express consent from the property owner that firearms were allowed. Next slide, please. So some thoughts for employers and business owners. Unless you're an employer that falls into the category of a sensitive area where firearms are going to be prohibited, such as a healthcare facility, for instance, you're typically going to fall under the category of a restricted area, which means that unless you put up a sign, firearms would be prohibited from your property. Nevertheless, this is a good time to review workplace violence policies and consider workplace violence training. With all the incidents in the news lately, it's just a constant reminder how important it is to stay up on that. And it's something that we've seen come up recently where employees reporting threats and bringing things to their employer's attention has played a really important role in keeping workplaces safe. So that's, something that we encourage you to consider. Additionally, even though you're going to be designated most likely a restricted area where firearms would be prohibited unless you put up a sign, it still might be a good idea to remind employees of workplace violence policies and policies regarding the possession of firearms in the workplace, just so that you don't end up with a situation that you have to respond to where someone maybe has unknowingly or accidentally brought a firearm on the property. Another thing to consider, if you are going to allow the possession of firearms on the property, to evaluate the potential risks and take appropriate actions to minimize them. Certainly there are some employers where There may be benefits to having firearms on the property or specific employees who are armed. But of course, having firearms on the property comes with certain inherent risks. So minimization of those risks should also be considered. And finally, employers should also watch for potential challenges to the law. This legislation was passed in response to a constitutional challenge. It's likely to be challenged again, I think. So it'd be a good idea to keep your eyes open for any potential challenges and any injunctions or other potential relief impacting the implementation of the law. Next slide, please. That should do it for me.
Thank you, Nick. Really appreciate it. That is an interesting topic, particularly for commercial tenants, and how that's going to play with landlords and preferences between landlord and tenant. So, Nick, thank you. We're certainly going to keep an eye on that, and like you just mentioned, we definitely anticipate legal challenges going forward. All right, next up, there was an interesting decision last week that we wanted to bring to your attention as it relates to COVID. And the next two presentations are actually going to be both COVID related. So I know we haven't had a lot of COVID content in the past couple of months, but there were some developments recently that warrant some updates. So here to talk to us about that case and what it dealt with and its potential implications is Janelle Doobie. Janelle is an attorney in our labor and employment department here in the Syracuse office where I am. And she's going to talk to us about that case. So Janelle, welcome.
Thank you. So good afternoon, everyone. And as Adam mentioned, I'm going to talk briefly about a recent state Supreme Court decision out of Cattaraugus County, which found that New York's regulation, which establishes isolation and quarantine procedures, is now unenforceable. So earlier this year, the health department issued a regulation which establishes quarantine and isolation procedures relating to COVID and other highly communicable diseases. The rule was originally set to expire, but has been repeatedly extended through July 20th of this year, and the Commissioner of Health is actually seeking to make the rule permanent. So for some background, Rule 213, as the regulation is referred to, states that whenever appropriate to control the spread of a highly contagious communicable disease, the state commissioner of health may issue or direct local health authority to issue isolation and quarantine procedures consistent with due process of the law to all such persons as the commissioner may determine to be appropriate. Additionally, for purposes of quarantine and isolation orders, the rule provides that quarantine and isolation locations may include the home or other such residential or temporary housing locations that the public authority deems to be appropriate, which can also include a hospital if symptoms or conditions indicate that medical attention would be necessary. So in response to the repeated extension of this rule, in April, 3 Republican state legislatures and a citizen group filed an Article 70 proceeding against Governor Kathy Hochul, the New York State Commissioner of Health, Mary Bassett, the New York State Department of Health, and the Public Health and Health Planning Council, challenging the enactment of the rule. They claim that the rule violates separation of powers and that the department, as an agent of the executive branch, didn't have the authority to enact the isolation and quarantine procedures that are contained in Rule 213. So in a decision issued on July 8th, the state Supreme Court judge who heard the case agreed with the petitioners and found that Rule 213 violates state law and is therefore null, void, and unenforceable. In determining whether or not this administrative rulemaking crossed the line into improper lawmaking, the judge considered several factors, including whether the agency balanced the costs and benefits according to pre-existing guidelines, whether the agency filled in details of a broad policy, whether the legislature has successfully tried to reach agreement on the issue, and whether the agency used special expertise or competence to develop the challenge regulation. The judge evaluated all these factors, but he specifically took into consideration pre-existing provisions under New York law. So he specifically considered Section 2120 of the New York Public Health Law, which already establishes a procedure for obtaining a quarantine or isolation order in light of a highly communicable disease. The judge ultimately came to the conclusion that the enactment of Rule 213 was invalid since New York Public Health Law 2120 already provides a procedure. He went into a specific discussion of due process protections and found that Section 2120 balances individual rights and the need for public safety, whereas this new Rule 213 contravenes the procedures already set forth in the law and ignores the balancing of individual rights and the need for public safety. The judge specifically noted that Section 2120 requires an investigation by a health officer and a hearing before a magistrate with the subject individual present. And if the magistrate finds that the person is a danger to others, then the magistrate can then issue an isolation order. In comparing Rule 213, the judge found that while Rule 213 does include some due process protections, meaning that it provides isolation and quarantine must be done consistent with due process, and that the detainee has the right to seek judicial review and the right to counsel, that these protections are effectively after the fact and would force a detainee to exercise these rights at a time where they're already detained, possibly isolated from home or family, or in a situation in which they can't obtain legal counsel in a timely manner. So the judge essentially determined that these embedded protections merely give lip service to the constitutional due process protections, because under Rule 213, the law could grant the commissioner very wide discretion to force anyone into isolation or quarantine, despite a lack of evidence that a person is actually infected with COVID or another highly communicable disease. He specifically noted that involuntary detention is a severe deprivation of liberty that is far more egregious than other health measures, such as requiring mask wearing in certain venues, and also that involuntary quarantine has far-reaching consequences, such as loss of income or employment and isolation from family and friends. So as a result of all of this discussion, the judge permanently enjoined enforcement and readoption of Rule 213. The respondents have filed a notice of appeal, so it is undetermined what will happen while the case is up for appeal, but this case is a good indication as to how the state will handle future health crises, based on the fact that during COVID we've had this expanded authority, emergency authority by state officials. And it's also unclear how this decision is going to affect other laws that relate to COVID, such as the COVID leave law, where benefits are provided to individuals based on a mandatory or precautionary order of quarantine that's issued by the state Department of Health or another governing body.
Janelle, if I could jump in here for a second, that was an excellent summary of the case. And it kind of threw many of our clients into a tailspin. Do we have to keep paying COVID leave? Are these quarantine or isolation orders still valid? And the answer is, we don't know. It's still in flux at this point. Everyone knows, and we all got accustomed to, that first year from March of 2020 to March of 2021, the governor had these extraordinary expanded powers, among which included the authority to give the Commissioner of Health the ability to issue these quarantine and isolation orders. Those powers went away in March of 2021. So the question became, well, how do we justify these continuing orders of isolation, orders of quarantine in this new rule? The one that Janelle was just talking about is what the Department of Health came up with. So now that the rule has been invalidated by a trial court, we're going to have to really wait and see what the appellate court does. So from a practical standpoint, as an employer, does this mean you can say to your employees, I don't care that you tested positive for COVID. We're not following the New York State Department of Health isolation or quarantine guidelines. We would certainly not recommend that you do that. I think that we should, the recommendation is that we take a wait and see approach, see what happens with this case. The Department of Health certainly is not taking the stance that the regulations are not valid anymore. The Department of Health, if you go to the Department of Health website, it's still very clear that they expect people to follow their quarantine and isolation guidelines. So we know what position they're taking. There's a lot of uncertainty. I wish we had a more clear answer for you, but at this point we don't. All we can do is tell you what has happened and what's going on. And right now we have a decision from a lower court, trial court, that's been appealed. And so I guess we will continue to report on this topic. Janelle, do you have anything else on that?
That's it from me.
Okay, great. Well, thank you very much for that summary. We appreciate it. Okay, next up, we are going to move on to another COVID topic. Next slide, please. The EEOC, under the cover of night, updated its guidance on EEOC or COVID testing and other things. And here to talk to us about those updates is Stephanie Fedorka. Stephanie, welcome.
Thanks, Adam. Happy to be here. Next slide, please. Before we do a deep dive in, I will preface that there are a lot of slides with a lot of content. My goal today is to really just provide the main updates and the most notable updates. But you have a link in the slides, and I can share that in the chat with where the updated FAQs are. And fortunately, the EEOC does update the with a date of which ones are updated, so you can easily search. On July 12th of 2022, the EEOC updated several aspects of its what you should know about COVID-19 guidance. Next slide, please. I think one of the most, if not the most notable update has to do with COVID-19 screening and testing. So this updated guidance provides in the affirmative that a COVID-19 viral test is a medical examination within the meaning of the Americans with Disabilities Act. So what that means is that employers can only require such screening and testing if it is job related and consistent with business necessity. So this to me sends a message that the EEOC is now taking the position that employers can still require testing. However, there's going to be a burden on employers to prove that such testing is job related and consistent with business necessity. In the guidance, it provides that if you do testing, if an employer does testing consistent with the CDC, FDA, or other state or local public health authorities guidance at the time of the testing, that will satisfy business necessity. In other words, if the CDC says we recommend testing at this point, or we recommend or advise testing at this point, following that CDC guidance or any local or health or state health authority testing requirements or guidance will prove that the business necessity standard. Other considerations that the guidance note includes with respect to whether or not an employer will meet this business necessity standard are things like level of community transmission, vaccination status of its employees, accuracy and speed of processing for different types of COVID viral tests, the degree to which breakthrough infections are possible for employees who are up to date on vaccination. And they link that up to date with the CDC's definition of up to date, which includes your primary series and any boosters that an employee is eligible for or as is recommended by the CDC. The ease of transmissibility of the current variants, possibility of severity of illness from the current variant or variants, what types of contacts that the employee may have with others in the workplace or where they might report to work. And they include the example of where employees are working with medically vulnerable individuals, as well as the potential impact on operations if an employee enters the workplace with COVID-19. The guidance emphasizes the fact that the CDC and other local health authorities and other guidance updates their guidance as to testing frequently and as the pandemic changes. So it encourages employers to check that guidance for updated information, again, at the time of testing, particularly with respect to whether or not testing will be or will meet that business necessity standard. Next slide, please. Thank you. In addition, employer notes a clarification for where employers can require employees who are returning to work after having COVID-19, they can require a doctor's note that states that it's safe for them to return to work and that the employee is able to perform their job duties. But it also added this note, so that doesn't really change from the previous guidance, but it added this note that employers can follow CDC guidance regarding whether it's safe for an employee to return to work without confirmation from a medical professional as well. Not really a big change. Employers still cannot require antibody tests to return to work because they will not meet that business necessity standard. And in so doing and explaining that, it noted that the CDC's current guidance states that antibody tests are not really determinative at all of whether or not an individual has a current COVID-19 infection or not, and therefore it's not going to meet that business necessity standard because those are also medical examinations under the Americans with Disabilities Act. Next slide, please. With respect to hiring and onboarding, employers can screen applicants for COVID-19 after making a conditional offer of employment, as long as it does so for all employees entering the same type of job. That provision of this guidance, or FAQ, if you will, didn't really change, but it added this clarification. If an employer screens everyone in that work site prior to entering the work site, so employees, visitors, applicants, contractors, everyone who's coming in, if everyone's being screened, and the applicant must be in the work site as part of the application process, for example, if they have to report to your work site for an interview, then the applicant may be screened as well. Again, provided that it is the same type of screening that everyone else is being subject to, and absolutely everyone else is being subject to said screening. But an employer cannot go beyond that screening, as that will cross that boundary into being an unlawful pre-employment medical examination. Next slide, please. With respect to the FAQ that was on in the guidance as to withdrawing a job offer, may an employer withdraw a job offer when it needs an applicant to start working immediately, whether at the work site or in the physical presence of others outside of the work site, because the employee has tested positive for COVID-19, has symptoms, or has been exposed recently to COVID-19. The previous guidance generally said, and in some substance, yes, if the employee cannot physically report to work, an employer can withdraw the offer. This updated guidance is more detailed, and there's more requirements now when that might be allowed and when it may not be allowed and run in violation of the EEO laws. So again, making reference to the CDC guidance, employers should consult the CDC guidance for when an employee or an individual, when it's safe for that individual to come and be in the physical presence of others and come to the work site. An employer who follows CDC guidance may withdraw the offer if the job requires an immediate start date. The CDC guidance recommends that the employee or the person not be in proximity to others, and the job requires such proximity to others, whether at the workplace or elsewhere. If those conditions are met, this updated guidance takes the position that it may be permissible to withdraw that job offer, but it also notes that some individuals may only require a short period of isolation or quarantine, particularly under the guidance that we have now from the CDC. And employers may be able to adjust the start date or permit telework, again, in light of that short time that an individual may be subject to quarantine. Next slide, please. Similarly, can an employer postpone the start date or withdraw a job offer because of an employer's concern that the individual is older, pregnant, or has an underlying medical condition that puts the individual at increased risk of COVID-19? No, again, the concern being that even if the employer's intention is benevolent and it's the concern for the well-being of an individual, that's not going to be a basis for withdrawing or delaying a start date. Or discrimination on the basis of age, pregnancy, disability, etc. It does note that if there's an underlying medical condition which does constitute a disability, which we'll talk a little bit more about in a slide or two, based on some updated or beefed up guidance in the updated guidance, then the employer has to determine whether or not the individual's disability poses a direct threat by starting work immediately. And if so, even if they do satisfy that direct threat standard, which is a very high standard to achieve, then they still have to consider whether there's a reasonable accommodation that can be provided to sufficiently lessen or eliminate any risks without causing an undue hardship. And in these types of situations, potential reasonable accommodation, right, provided that there's some direct threat actually satisfied, which we'll talk about, A reasonable accommodation could be a delayed start time or delayed start date, as opposed to just withdrawing the offer altogether. Next slide, please. There was an updated FAQ on age, which I summarized here. As you likely know, the ADA, the Age Discrimination in Employment Act, prohibits employers from discriminating against employees on the basis of age, which at the federal level is 40 and older. Employers cannot involuntarily exclude older workers because they believe to be protecting them due to a higher risk of severe illness, similar to the previous FAQ. But what was interesting in this updated guidance is that it highlights that the ADEA does not include the right to a reasonable accommodation due to age, but employers are free to provide flexibility to older workers, even if it results in younger workers being treated less favorably. But I would note, so that's interesting to me, and I would note that in New York State, age discrimination applies 18 and over. So while there may be some guidance from the EEOC saying that maybe you could be flexible with older workers who may not be able to come to work, or there's some concern about COVID-19 in the workplace, take that with a grain of salt and consult a legal professional to really emphasize, what the risk is there. Okay, in light of time, we'll go to the next slide, and I want to just highlight one more big piece that I think is important. Next slide. The delays in the interactive process, again, was a very quick update, just saying that we're really returning to a prior standard where originally the EEOC said the pandemic may have contributed to delays in the interactive process. And it recognizes in this updated guidance that a lot of those conditions and situations really don't exist anymore. So employers really should go back to promptly engaging in the interactive process. Next slide, please. This is the slide I really wanted to emphasize, and I won't go through everything, but it's the case again, a similar topic as before, where just because an employer knows that an employee has a medical condition or some condition that may make them more likely to become severely ill from COVID-19, even if the employer is concerned about the employee's well-being, there's a couple things at play here. One is that an employer doesn't require an employee, the ADA does not require an employer to take action if the employee has not requested a reasonable accommodation. So just because you know that an individual or an employee has one of these medical conditions identified by the CDC as potentially causing people to get severely ill from COVID-19, if an employee has not requested an accommodation, no accommodation needs to be provided. If the employee has requested accommodation, that triggers the interactive process obligations as normally would under your interactive process and reasonable accommodation policy. It really emphasizes this direct threat analysis and emphasizes that this is a very high standard. You have to consider things that it's got to be individualized. It can't just be based on a presumption that an individual's disability or medical condition it does provide some sort of threat to their own safety or the safety of others. And then even if you do satisfy that direct threat analysis that I have bolded there, again, considering the duration of the risk, nature, the severity of the pandemic is another consideration, the employee's own health, whether they're mitigated or not, you still have to consider whether or not that could be accommodated and whether or not there's a reasonable accommodation that could lessen that threat. So with that, in the interest of time, I will hand it back over to Adam.
Thank you, Steph. And there are actually quite a few more slides in here for you that summarize the changes that were made by the EEOC this past week. So if you get the presentation in your email and you want more specifics regarding those changes, there are a number of slides here. All right, Adam, if you could go forward all the way to Lou and I. Okay, so next up, I get the distinct pleasure of presenting with Lou DiLorenzo this week. His partner in crime, Jeff Keel, is unavailable, so I was able to fill in. And what we're going to be talking about today is a really interesting topic in the world of labor and employment law, and that is the faithless servant doctrine. And it is, in general, it deals with an employee who does something really bad, as Lou's going to talk about, and a way for an employer to potentially bring a claim against that employee. So Lou, why don't you start us off with a general overview of what the faithless servant doctrine is? Next slide, please.
Thanks, Adam. And it's always a pleasure to present with you, Adam. Thanks. Good afternoon, everyone. So the faithless servant doctrine, this is a very old doctrine in New York State from the 1880s, I think, common law. There's no statute. Why are we taking your time today to talk about it? Because I think you should be aware of it. You should keep it in mind. And it can be a very, very useful tool in the world in which we live in terms of employee conduct and so on. Basically, what it says is that it takes this concept, which has been recognized, for centuries, that employees are supposed to be loyal to their employer, right? Don't bite the hand that feeds you. Be loyal, fiduciary duty of loyalty, very, very high standard. We see it in the restrictive covenant cases. We see it when people are supposed to be doing work and they're diverting work to another company, or they're planning on starting their own company. Those are all fiduciary concepts. You're supposed to be undivided attention, looking out for the best interests of your employer all the time. So what the faithless servant doctrine is, it's a little bit of an extension where an employee does something wrong, is disloyal. If we can say the employee is disloyal, what it means is obviously they breach their fiduciary duty. It's always been a basis for a cause discharge. It's always been a basis for defending against a discrimination complaint. This person was disloyal. This person failed to cooperate in a workplace investigation. This employee failed to follow my instructions, thought they knew better than I did as to what was to be done. Those kinds of things. We always know it's been a very good defense to a claim, but the faithless servant doctrine is more than that. The faithless servant doctrine is not just a shield against claims that have been brought by employees, but it can be a sword in the hand of an employer who wants to go after an employee. And that can be in the way of a claim, or it can be in the way of a counterclaim in a suit. And basically, the bottom line is that if the employee has been disloyal, is engaged in a breach of their fiduciary duty of loyalty, from the time that they committed that breach, they are not to receive compensation or benefits from the employer. In other words, if I was disloyal, breached my fiduciary duty of loyalty to you, then all those paychecks I received and all that compensation and all those benefits that you gave me, I should have to return. I should be, I think the proper damage description is, I should be disgorged. Those benefits and compensation should be disgorged from me. I should have to give them up and return them. Now, there's a lot of nuances that flow from that. And frankly, they're pretty good for the employer. One is that there doesn't have to be a matchup of the amount that's disgorged compared to the amount that the breach that or the damages that the breach cost. The easiest one probably is embezzlement. An employee who steals from his employer. If you can establish that from the point of the stealing, if you can establish that date, that employee is supposed to give up their compensation from that day forward.
Lou, let me interrupt you for a second, and I'm going to actually go to the next slide because we have a great example of exactly what you're talking about.
You're right, Adam.
Next slide, please. There we go.
So
this is actually a case that we handled.
That's right.
In 2009. So Lou, go ahead.
Sure. So Howard Miller in our Garden City office brought this claim against a disloyal superintendent for business and assistant superintendent of business, who were actually ended up, the classic story. They went on vacation, or one of them went on vacation, and while they were on vacation, certain things were discovered, and those things that were discovered led to the discovery of $1 million, roughly $1 million of embezzlement over several years. The employees were sued under the Faithless servant rule by Howard, and this was really a dust off of the cases that had been around since the 1800s. This is kind of the modern, Howard's use of this statute was kind of the modern resurrection of the Faithless servant doctrine in New York. And he recovered a judgment that I think went back about 12 years. I'm sorry, it went back about 12 years. And what the judge did was, in the case, found that it was an equitable principle and said, look, it looks like a couple $1 million was stolen, and so I'm going to give you a couple $1 million worth of compensation. And it's going to stop there. And Howard said, you know, I've read this statute, and the statute doesn't say you balance out how much they took against how much you can recover. It says they're not supposed to get any money for the time period that they were disloyal, no matter how much they took or what the damage they caused their employer. And Howard argued that includes the lifetime retiree medical that they've earned because they've worked more than 20 years for the district. The judge said, no, that's too much. It wouldn't be fair to them. They worked for you for 20 and 25 years, and presumably some of the service that they rendered was legitimate, so you shouldn't be able to get 100% of the compensation. Howard disagreed, so that's not what the doctrine says, so he appealed. They both appealed, but he appealed this portion of the decision. And the second department said, you know what? You're right. It's all the compensation. It doesn't matter how it measures up, and it can include future deferred compensation, such as retiree medical, retirement plans, pensions, and so on. There's a case in New York, a recent case, where about $50,000 was embezzled, and the court awarded $300,000 in compensation that was paid from the point at which they could prove that the embezzlement occurred and continued. So it's a very, very valuable doctrine. It has a funny, unusual, funny statute of limitations. It's basically a 2 and 3 year statute of limitations, 3 for fraud, 2 for just normal breach of the duty. But there's a tolling provision, which basically says if the employee during the employee's employment concealed this faithlessness, which is obvious that it's almost always concealed, the statute doesn't begin to run until they're terminated. So effectively, we have a statute of limitations in New York of 2 and 3 years, but it doesn't start to run until the employee's terminated. And presumably you start to discover some of these things after the termination. It's a very valuable doctrine. In the slides that Adam has, there's a slide on a case in Massachusetts where a CEO who had been repeatedly disciplined for sexual harassment, violating the company's sexual harassment policy, was terminated, and they used it to they cited the Faithless servant doctrine in New York, Howard's case and the William Floyd School District case as well. They cited those cases and said, you know, this is really a breach of the fiduciary duty that a CEO has to his company to follow important policies. The sexual harassment policy was repeatedly violated. He caused the company a great deal of damage, financial and otherwise, and therefore he should forfeit, I think it was $20 million or $10 million in termination pay. And the Massachusetts court extended it to that situation. Now, that's the furthest I've seen the Faithless servant doctrine extended to a breach of a fiduciary duty. I haven't really heard a CEO's obligation not to engage in sexual harassment to be a fiduciary duty. So it's pretty much been limited to fiduciary duties, but I think you're going to see it extended, and it's something that can be very useful. You get sued for discrimination. It could be a counterclaim on something you discover later. I would be careful with it. On the counterclaim, we have a case going right now in federal court where the other side is trying to use a faithless servant counterclaim that was asserted to claim that it was retaliation. In other words, the counterclaim wasn't brought until after the lawsuit was brought. That's true. And there's a standard for whether counterclaims can constitute retaliation, but still should be evaluated.
Absolutely.
It's a very useful tool. It can be incredibly powerful, and you shouldn't overlook it. You shouldn't think in terms of when people steal from you or they do things wrong, a breach of fiduciary duty. You shouldn't just think in terms of I've got a basis for termination. I've got cause for termination. You may have more than that. Instead of just a shield, you may have a sword. I'll stop there, Adam.
Thank you, Lou. That's great. And I will point out a couple of things. One, this doctrine is typically reserved for the most egregious type of conduct. Embezzlement, obviously, is the clearest example, but there are other cases involving insider trading, unfair competition, off-duty sexual misconduct. There's a recent case from this year actually involving a physician who was involved in falsifying claims to Medicare, and a court upheld a faithless servant ruling against that physician. So this is definitely a good doctrine. It is reserved for the most extreme circumstances, and we hope that it's useful to you. Well, we don't hope that it's useful to you at some point. Hopefully you never have to deal with this issue, but knowing that it's there, I think is helpful. All right, well, I don't want to keep you any longer. Thank you so much for being with us this week. We will see you again next week.